Okay, well, I think we can go ahead and get started. I will let people into the room as soon as they join. Hi, everyone. We have a very, very exciting topic today. We are going to be talking about leasing during COVID-19. We have a very special guest with us today. We have Dylan Pichulik from XL Real Property Management. Hi, Dylan.
Hi guys, how you doing?
Doing great. We're also here with Andrew Luftig and David Goldfincher. Andrew, if you'd like to take it away.
Sure. I'll certainly let Dylan have the floor, but I think just a starting point, if you haven't, heard me say it already, I wholeheartedly believe that rentals is definitely, the gateway, the segue for building business in today's market. I'm sure Dylan's been on the phone every day, all day. I know David from our team has been as well. Everybody knows somebody with a rental question, a rental issue. Do I pay my rent? Can I get away with not paying my rent? Can I get a reduction? The courts are closed. What do I do? My lease is expiring. So, while, the newsletters about the spring buying season are not so relevant right now, putting out information, we have FAQs. I'll add our firm website. We have free downloadable information on our site that you can put on your social media or email to your circle, and you can connect with people and be a resource, be a voice of reason, kind of talk through scenarios. Listen, you may not have all the answers, which is okay, but it's, you can come to us, come to, another attorney, go to another attorney. And just I think you want to engage with, right, your clients and their friends and their family. You want to get communication going again. Inevitably, and this is what happened with us, we're meeting more, and there's a silver lining to all this. We're meeting literally hundreds of brokers that we didn't interact with before because of our landlord-tenant practice. Now, you may say, Andrew, I'm a purchase sale broker. I don't really pay attention to rentals. If they come, every now and then I'll get involved. But I think, I have a line of saying that if you haven't changed your marketing or business practice, if you're doing the same thing you were doing, 2 months ago that you're doing now, right, it's probably not the best approach, right? We have to shift. We have to reacclimate to the new situation. So I think part of that is engaging in the rental world. I literally, this is not a lie, just got a phone call from a broker, said, Andrew, thank you so much for the discussion. And now sometimes I'm too quick these days. I said, is it a rental question or purchase sell question? Because I don't want to waste my time. I don't want the broker to go on for 10 minutes and to find out it's a rental question. I'm just going to, relay them to David. They said, no, it's a rental question now, but they're going to be selling. So think about that for me, right? So now this opportunity has, provided, that the only reason that broker is calling me is because of the rental practice, right? So there is definitely 100% a way for you to build business, build connections, and plant seeds. And these seeds, may not come to fruition for 3, 6, 9 months a year, but, it's definitely a model that I think isn't being taken advantage of. And along those lines, of course, we're dealing with mega landlords, the landlords that, own single condo and co-op units. I think that's where, David comes into play. Dylan comes into play, and David, but more so Dylan. Dylan, you want to give us a kind of little background on the practice? And I know there's a bunch of questions that were already emailed, which is great. And we have a nice intimate crowd. So definitely, feel free to chime in. You can unmute yourself with questions, or if you feel more comfortable, type in questions. But Dylan, give us, I guess, a little bit of background on what you do, and then kind of how it, what's your today's world for you? What's that all about?
Perfect, great. Thank you so much, everyone, for joining. It's so great to see everybody. I know it's tough circumstances, but it's good to see familiar faces during this time. I'm Dylan Pichulik. I'm the CEO of XL Real Property Management. As many of you guys know, XL specializes in managing individual apartments and small buildings on behalf of absentee owners. So we're the go-to resource for clients that you have that own individual units or even townhouses and don't want to deal with the daily onus of management. And what makes us unique as a management firm is we actually don't practice brokerage. So that relationship always stays with you. We just take care of the operational activities of the assets. To jump into the topic, it's definitely been a very challenging time for us as landlords. We share a lot of mutual clients, both with Andrew as well as many of you guys on the chat. And there's been a lot of panic within the rental industry. And I think landlords are very concerned, tenants are very concerned, and there's been a lot of recent legislation that was passed that we have to navigate. So that set the tone for how we're dealing with circumstances these days. The most frequent question that we're getting is, what do I do about rent? And some tenants are able to pay rent, some tenants aren't able to pay rent. And how do we navigate that given the legislation that's been passed? So to kind of set the tone for that, should we jump into the, how do you want to do this? Should we jump to the legal part of it, Andrew, or talk about
David,
what's out there?
give a quick back. It's good. I mean, I think the ideas are mutually aligned at this point. It's funny because, pre-corona, we may look to a lease for a certain situation. And as an attorney, it's kind of contradictory for me to even say this, but you can almost keep the leases in the drawer, right? It's more of a discussion and negotiation, communication, being reasonable. And this is where, I think you as brokers have more value than, in recent years, because it takes, a real estate professional to come up with a creative approach, right? It's not a square peg in a square hole anymore. It's a pragmatic, practical approach. You have to calm your clients down. You have to give them reasonable expectations. You have to be creative. You have to be able to, no pun on words, but broker a deal, work out a deal. So David, you want to just give a quick legal perspective? I'm sure it's pretty much the same. It's very similar to what Dylan's having to say, but, give us your 2 cents.
Sure. Yeah, hey everyone. So just to piggyback off what Dylan started talking about, as far as rent payments are concerned, we're getting questions like that all day, every day. But as we sit here today on May 12th, rent payments are due as usual, as per the terms of the lease that you signed. There's been no law or legislation passed down that waives rent for tenants or even offers a suspension of rent. So again, as we sit here right now, rent payments are due as always. But that being said, of course, many tenants are having trouble with their rent payments. And it's not just rent payments they're having trouble with. There's a lot of issues as far as move-ins, move-outs, taking possession of apartments for which they sign leases for. So there's a whole web of issues as it relates to landlord-tenant law. And unfortunately, we can't just flip open the state legislature and see how to deal with these issues in the COVID-19 world, because it simply never existed before. So there's a lot of maneuvering that we're doing. We're sort of, instead of interpreting laws like we usually do, we're acting as problem solvers and doing a lot of negotiations between landlords and tenants. So a lot of adapting that we're doing right now, a lot of brokerage, like Andrew just mentioned, brokering deals. And the important thing to take away from this is that rule number 1, I would say right now, is that communication is key. If you're representing a landlord or a tenant, make sure the parties are communicating clearly to each other. If you're a tenant who can't pay rent, communicate to your landlord. And if your landlord hasn't received the rent, tell the landlord to reach out and say, hey, what's the story with the rent? When can I expect it? Are there any issues going on? It's very important to speak these problems out and see how the parties can help each other here.
Right, and that's a very important topic that David makes. And the name of the game in this particular climate is communication. And there's been, overall, just to give you guys an idea of what we're facing as a management company, we run sort of from kind of upper middle to upper end of the market from a portfolio standpoint. And to give you an idea of how much we're impacted, I would say rent payments for us, we're down only about 10%. So 90% of our tenants were able to make the rent payment. We only had issues with about 10%. And in this climate, for many of you guys, you might know, currently housing court's been suspended until at least August 20th. So until August 20th, the landlord's not allowed to file any new landlord-tenant litigation regarding non-payments or anything outside of just sheer emergencies, like my landlord's locked me out of the apartment or something like that. And because of the guidance, because we don't have the support of the court right now, really communication is the most important concept, because we've got to strike deals with our tenant. Yes, as landlords, we're normally going back to the lease to say, well, the payment says X, here's the terms, X, Y, Z. But without having the support of the court, we've really got to get creative and make deals with our tenants, whether it be deferments or discounts. But really, we've got to realize that the landlord's in a compromised position, more so than in other markets. And, especially since those new June 2019 rent laws passed. But the landlord's in a compromised position, and without the backup of the court, we've got to make deals and do whatever we can to keep our tenants paying and keep things flowing as smoothly as possible. And one of the most frequent questions that I've been receiving is, how much discount are you giving to tenants? What type of terms are you negotiating? And I would say that it's widely dependent on the circumstances. How long has our tenant been in place? What's the rental value of the apartment? What was our track record with the tenant before? And that really determines how we're going to act. But for the most part, I would say discounts vary. We're seeing sometimes the tenant just needing a slight break, and sometimes we're seeing larger breaks. But in those small breaks where the tenant's just looking to get something in some sort of relief, I would say discounts are as low as, let's call it 10% so far for the months of April and month of May. And that a lot of times satisfies the tenant. However, if you've got a tougher circumstance and you're worried about a vacancy and the tenant really needs more relief, there have been cases where we've given as much of a month of discount just to ensure we get those payments, that the relationship doesn't deteriorate, and we can float the owner, a little further down the road until we have more clarity in the situation, or at least until brokerage opens up and we can more effectively show our properties.
Yeah, and I would just add to what Dylan was just started off saying before. It's very important if you're dealing with a landlord client. You have to help them understand that all the leverage is with the tenant right now. And I sort of saw the transition from the attitude of landlords from a couple of months back when this first started, and tenants were bombarding landlords with rent discounts and so on and so forth. At that point, many landlords that I was speaking to were taking a hard stance and saying, listen, you signed the lease. I expect you to honor the terms of the agreement to the fullest extent, and I'm expecting you to pay rent in full every month. I think in the weeks since, landlords have really been seeing that the leverage is completely on the tenant side, and they're going to fight a losing battle by drawing a hard line in the sand. So I'm seeing a lot more concessions on behalf of landlords, and they're sort of softening their approach here and saying, hey, listen, if I can get 60-75% of the rent right now, I better take that instead of being aggressive and saying I'm only accepting 100%.
Yeah, and that makes most sense because, look, we want to make sure we're collecting the most that we can. And the alternative, to give you guys an idea, if communications fall apart and the tenant doesn't pay rent, housing court doesn't open until August 20th. After that point, you've got to understand they're going to be dealing with an avalanche of these types of cases, simply because we've had at that point about a 6-month suspension in court. So not only do we have to wait till August, we then got to get through the avalanche until we even get our turn in court. We could be well into fall and winter before we even get in front of a judge and start going through the process. So would the landlord rather have 50% of the rent today and avoid that process? I would say in this circumstance, yes. Normally as landlords, we do take a hard line. We want to be as tough as we can. But in this case, as David mentioned, the tenant has the upper hand. The tenant can say, fine, I'm not going to pay rent, sue me. And we've had tenants say that in some circumstances, and we've got to make the best deal we can, because if my alternative is to sue them, that's really not a pretty outlook. And in some cases, the landlord will have to. We're going to have situations where the tenant's being unreasonable and we're just unable to strike a deal, and the mathematical equation makes sense for us to go to court. But unless you have a substantial amount of money you're fighting, the court process might not be the best bet. And really, and I just saw Julia Jang just posted a question. I'm sorry, Julia, I got rid of that question, disappeared for me, but it was about taking rent payments today. But the most, look, you want to make the best deal you can and most importantly, keep the tenant paying. And also keep in mind, we want to keep that tenant happy. We want them to renew the lease as well. So we want to, in some cases, extend that olive branch even a little further to keep them happy during the climate. So if their lease is up for renewal soon, that they have a good feeling and they're more likely to stay with us.
Yeah, and and the flip side to that is if you're a tenant, you should obviously make sure that you're acting with a level of integrity and honesty, and you're not just asking the landlord for a discount or a rent break just because other people are. Dylan just mentioned the landlord throwing the tenant olive branch. The tenant should also keep in mind it might be a good idea for them to throw the landlord an olive branch in the event that they want to renew their lease at a favorable rate down the road. So these are things to keep in mind. Both parties should try to take the long view here, and whatever they do now might come back to play a big role later on.
Right. And Julia just reposted her question, and it's, Dylan, can the tenant just tell the landlord, I'm only going to pay you half the rent without the landlord's approval? The legal answer to that is no, they can't just do that. But the in practice reason right now, for all practical purposes, because there's no court, they can pay that amount. The landlord can always go after it later. But for the time being, there's not a lot the landlord can do. But if the tenant only wants to pay half, maybe work out and strike a deal with them. Fine, we'll give you half the rent for X amount of period. Always make sure you pay for the agreement. Never have a verbal agreement with the tenant. Those always come back to bite you later. So whatever deal you do make sure that it's documented in writing. Also, I do want to address the second part of our question, which is, can landlords report tenants to credit bureaus? And the short answer, you'll see a lot of things online. Oh, you can instantaneously report a tenant to a credit bureau and give them a bad credit rating. But the reality is it doesn't really function like that. I'll let David and Andrew answer more of the legal component of that. But until you actually have a judgment in your hand that hasn't been satisfied, I don't know if you can really go to a credit bureau about it. The second part is the best tool the landlord had prior to the June 2019 rent laws was that we could threaten the tenant and say, look, if you don't pay your rent, I'm going to put you on the landlord tenant blacklist and you'll never be able to get an apartment in New York again. And that carried a lot of weight because I, as a landlord, when I got the credentials from a tenant, I would look at the housing court history. And if you had a record, the landlord doesn't really want to touch you. I don't want to have a tenant that I'm going to potentially have to sue. I don't want to go to court. I'd rather have a tenant that'll work it out with me in a reasonable way. The problem is in June 2019, they took away the landlord tenant blacklist. And they said, if the landlord views it, we're going to consider and uses it as a basis for accepting a tenant, we're going to consider that discrimination now. So you're not allowed to view those. So as far as reporting to a credit agency, you'd have to have a judgment and the tenant have not paid it by the time you could even potentially get to a credit reporting agency in a legitimate way. So the shorter answer to that question would be, don't necessarily bank on that. And that's why more and more important, and we hear that a lot, oh, I'm going to report them to the credit agency. It doesn't really function. We did try to do that a few times just to see like what would happen. Because if you Google the concept, you'll see a lot of people that said, oh, you could do it. And basically it just resulted in some lost, money for the administrative fees and nothing really happened.
I would say relying on any, from a landlord's perspective, relying on anything in landlord-tenant court down the road is a very risky strategy right now. I tell people all the time, even during pre-COVID-19 days, landlord-tenant court in New York City wasn't exactly a model of efficiency. So we could all use our imagination and see how that's going to look once this all passes and the courts reopen. And there's a line of landlords snaking around Lower Manhattan trying to get into court and start non-pay cases and holdover cases against tenants. Number one, courts are notoriously tenant-friendly in New York City. So how's that going to work? Number two, do we really foresee a scenario where judges are going to across the bank enforce these judgments against tenants who are unable to pay their rent? It's hard for me to see that.
Yeah, and even in a good day, even before the pandemic, as David mentioned, the housing court is not really a friendly place for the landlord. The court system doesn't want to contribute to the growing homeless population of New York. So they'd always notoriously been very tenant-sided. And, as a reminder, the June 2019 rent laws, the official name of the legislature was the Tenant Housing and Protection Act. It had nothing, it didn't say Landlord Protection Act. It was geared specifically towards the tenants, and that's how the court system implements it. So it's not a friendly place for a landlord. A lot of landlords, in a moment of, kind of frustration, want to go the legal route. And there are circumstances where you have to, but I would do everything in my power to dissuade a landlord from going that route if I felt a reasonable deal could be made. And imagine many of you guys on this panel all operate in sort of upper portions of the market. We're not, most of you guys are not doing, $1,000 rentals all the way in deep Brooklyn. So, when you go to court, the judges are going to view kind of the situation a little differently than, how they might enforce like where a landlord's being, nasty to a tenant or something and the tenant needs help. The courts really aren't going to be too helpful for us.
Just on Phil's question, yeah, emails, text messages are no bueno. You want, a ride or an addendum. And this has kind of been my mantra, today's world, today's environment, it lends itself to cutting corners. Like, you want to get things done, you want to help your clients, you want to collect a commission check, you know, everything takes more effort. You know, it's painful to close deals, painful to get, you know, leases fully signed, but, you know, clients are your best friends until they're not, right? You know, 2-3 months down the line, they'll forget all the favors you did for them. They'll forget that you jumped through hoops. So you want to paper these. And listen, I know how it works. You don't want to get attorneys involved because your clients don't want to spend money and they're already losing money. But you have to do it the right way because you have a license, we have a license. You just have to be careful, right? You can change, you know, anytime you make a legal change to a document, an attorney's supposed to be involved. You know, a lot of times we're helping clients, you know, not to say, or, you know, helping clients within a few minutes. You know, David can jump on the phone in 5 minutes and resolve an issue. Sometimes it takes a little bit more effort and time, but a lot of this stuff is pretty basic, pretty straightforward for us. So we're, you know, doing a lot of favors. You know, we're all helping each other out a lot. I think the community is as a whole. But to answer your question, you know, do it the right way. It's not worth it. You know, people forget very quickly that you did a favor for them.
And also keep in mind, if you do go to court on it, the first thing they're going to do is ask for the document that memorializes it. And if you have nothing, it's, you know, it's going to be an instantaneous, you know, ruling against you. If you ever get to that point, which is months and months and months and months down the road.
Yeah.
So we had some other questions. What's the latest with move-in and move-outs?
I'll address that one.
Yeah.
For the most part, buildings are still allowing move-in and move-outs. The larger buildings you tend to have a little bit more problem with than the smaller and mid-sized buildings. Moving is considered an essential service. However, for buildings that aren't, you know, always check in advance to make sure the building is allowing it. Every building is operating differently. Like I said, we've had much more success in the smaller and medium-sized buildings than the large ones. But if the building does prohibit it, they prohibit it, and you can try and push back. We have had some success where the building policy was a no, and we've been able to get it overturned. So I would say check each building on a case-by-case basis. And if there's a legitimate reason, like, for example, we had a future tenant who was pregnant. So the building gave us a waiver for that because they understood, you know, there was already a very stressful situation for our tenant. They waived the restriction. So check each building on a case-by-case basis.
Yeah, and listen, we still want to be sensitive, but we can be a little bit less sensitive than we were 8 weeks ago, right? Things have progressed, things have changed. So managing agents, and this is more for co-ops and condos, I guess, than, you know, full rental buildings, but managing agents don't set the policies. Boards set policies, and managing agents implement policies. So if they're still, you know, kind of stuck with 8-9 weeks ago, you know, saying that we're not allowing movers, you know, the moving companies can't, do things adequately to protect, you know, the safety of the building, that may not be accurate anymore, right? These moving companies have changed. Everybody's acclimated, or hopefully most people, professionals, have acclimated and changed routines, changed policies and procedures. So at this point, still be respectful and still be, you know, aware of the environment we're in. But I wouldn't hesitate to reach out to somebody on the board and say, hey, listen, you know, what's going on? You know, all the buildings in the neighborhood are allowing this. You're not. You know, the analogy I give is 8-9 weeks ago, the first building I had to do a virtual interview was the Dakota, right? So if an old school, you know, Manhattan co-op is allowing virtual interviews, you know, why can't these other buildings, right? It's obviously, again, making sure that we're sensitive to the situation, but you're allowed to ask, you're allowed to inquire, you're allowed to prod a little bit, especially at this point. You know, we want to get deals going.
Right. And on the same topic of move-in and move-outs, because we are in such a difficult situation and turnover is not the easiest, because even if tenants can move in and move out, doesn't necessarily mean that the building will allow you to do things like paint the apartment. So if you do have a lease that's coming up for expiration soon, and the tenant's unwilling to sign a 1-year renewal, we typically want to strictly abide by turnover season, which is, you know, spring and summer. You know, I think we're a little bit more relaxed on that. If we can get our tenant to extend the lease for even 3 months, just to give us more time to get the apartment in the market and operate into the new climate, I would definitely not hesitate to do that. A lot of people don't want to commit to 1-year leases right now, we're finding this summer, because there's so much uncertainty with the economy and their job and all the other circumstances we're facing. But see if they'll give you a 2 or 3 month extension, at least get us to a point where hopefully it's legal for everybody to show the apartment and we can operate as normal as we possibly can. Because, you know, we're definitely doing deals now. Apartments are still renting even today, but it will be much easier, presumably in, you know, a month or 2 months or 3 months from this point.
There's a question here about, do you think developers will lease to own option? Well, I think, you know, first, deals in contract, it could be a good option, right? Because obviously everything's slow with the Department of Buildings. So if a tenant needs to get into the property, they can, you know, waive their drop dead date and potentially, you know, maybe an option. You know, will they, as far as negotiating new deals, create that? Yeah, it's definitely not their goal. I think they'll have to be in a pretty precarious situation to allow it, but, you know, we may get there. We spoke about concessions, you know, larger landlords giving consent. Do you see a difference between, you know, I guess you're dealing more with the condo co-op landlords, right, Dylan, as opposed to the mega landlords?
Yeah, we deal mostly with smaller landlords who own 1-2 units. And, you know, look, bigger landlords can definitely stomach concessions a lot more than a smaller landlord could, just, you know, based on sheer cash flow. But that being said, I mean, this is a time where, especially if you got a lease up for renewal and the tenant's on the fence about renewing, I mean, we're definitely being much more heavy-handed with concessions than we've ever been before. Because look, our goal is, you know, if we got a tenant in place, even if we lose a month rent, we give them, you know, a month of concession, or do a rent drop of even 10% in some cases. The alternative is, yes, it is possible to rent the apartment to someone else, but, you know, that comes along with a lot more risk. So even smaller landlords, you know, even if they're hesitant to do it, you know, we're encouraging it. You know, I'd rather, you know, if we lose the tenant ultimately, and we've got to paint the apartment, which can cost us, you know, maybe a half-month rent, and we've got to find a tenant, we'll have some level of vacancy loss. We've got to potentially pay a broker fee of 1 month rent. I mean, we'll do much better if we can keep that tenant in place than if we risk having the apartment go vacant. That being said, if the tenant, you know, some tenants are coming with completely unreasonable deals, drop my rent for 50% for 7 months. You know, that's obviously unreasonable. You know, if we can get you to a reasonable level, you know, a month, maybe we'd go even a little higher if we had to, but, you know, some tenants are just coming, you know, the vulture tenants are coming to make, you know, crazy deals. And, you know, those I would shy away from more than, you know, hey, I normally don't give a month, but in this case we would.
What about discounts for amenities that aren't open? Is that, I guess it's all part of the same idea.
It's part of the same idea. We have gotten that gripe a little bit. And for me, I don't know why I find it like particularly disturbing. It's like, come on, like we're all in this huge crisis and you're calling us to complain that you can't use the pool or, you know, or use the gym. And, you know, look, we're understanding of it. If they're asking for a small discount for it, you know, look, we don't want to give it, but the only thing, you know, we want to keep our tenant paying. We want to keep them in place. So if we have to give a small discount, hey, look, we'll give you you know, on something like that, I would say, you know, maybe $200 a month we'll give you till it opens again. You know, we want to keep things sweet because we want our tenants to renew. We're looking at a, you know, more uncertain market, so we want to do everything we can to keep you happy. And if you need $200 because you couldn't use the pool, then, you know, now's the time we'd probably give it to you.
How possible will it really be in the future that my client will be able to collect only 1 month of unpaid rent after already using the tenant security deposit for April? Tenant moving out June 1 and didn't pay May.
That would be more of like a you and David question, but
Yeah.
you know, I don't know if I'd go to housing court to chase a month of rent. You know, you got to keep in mind legal fees that you're paying and everything else.
Yeah, I would
count
say
on
the
it,
chance.
but let's hear David's perspective.
Yeah, I would say the chances of recovering that are slim to none. And you know, just a quick word on security deposits. Obviously, this is something that's extremely prevalent now with tenants using security deposit in lieu of rent. And just you know, dialing back to what Dylan was talking about earlier, if that happens, make sure to put that in writing. You know, don't rely on a text message or an email from between landlord and tenant saying, "Hey, here's my deposit. Take it for rent." You don't want to be in a situation where the tenant is vacating the apartment in a couple of years from now, and they're saying, "Hey, where's my security deposit that has to be returned within 14 days?" And they forgot to use it for rent in May of 2020. So again, this is another example of something that should definitely be formalized in writing if both parties are agreeing to use the deposit in lieu of rent.
Let's see what else we have here. What can be done when the landlord lets the tenant know that he will not be renewing the lease, but the tenant refuses to leave?
Yeah, so I mean, during normal times, that would result in a holdover proceeding. The landlord would commence a holdover. Obviously, where these are far from normal times, and from my perspective, it doesn't make whole lot of sense for landlords to sort of take that hard stance and say, "I'm not renewing your lease. It's expiring. You have to leave." It's nonsense. We should all probably just be under the assumption that the tenants are probably going to have to stay here for the next little bit. So you might as well try to, like Dylan was saying earlier, try to get a short-term extension. You don't have to commit yourself to a 1 or 2 year renewal. You can get a 3-month, a 6-month extension option, and you can also build out certain cancellation clauses for both parties. Different termination ideas in order to maintain a level of flexibility, because none of us know what's going to happen in a month, 2 months, 3 months from now. So best to try to maintain a level of flexibility, and as a landlord, understand that your tenants are probably going to be here for the foreseeable future, next couple of months at least. So try to work it out, paper renewal, and just work together on this.
Yeah, and also keep in mind, there are some buildings that just aren't allowing move-outs. And we've been stuck in that situation with a few people, particularly one that comes to mind is at the Plaza, where they're not allowing any move-in and move-outs. So we had a tenant's lease expire, I think, at the end of April, and they won't allow them to move out. Sometimes it's not even the tenant's fault that it's happening. But even on those deals, the tenant saying, "Oh, I don't want to renew. I'm out. I'm not going to pay rent, but I got to leave my stuff in the apartment." So sometimes we do have to bite the bullet and, just eat that as a, concept, at least until move-outs are permitted.
David, we went over a situation recently where, you can unintentionally extend the lease when you're trying to work out an agreement, just a short extension, but it's extended by, do you remember the scenario?
Was that the month-to-month situation?
Not the month to month, but when, we've seen issues where brokers kind of work on lease extensions, and then, it turns into giving the tenants or the landlord more rights than they anticipated.
Well, yeah, I mean, this comes into play certainly with rent abatements. If you're negotiating a discount in the rent between the landlord and tenant, now you have to be very careful, because it can result in whatever the abatement or the discount is going to be. It can result in that being the new set amount of rent for the indefinite future, as long as the tenant remains in the apartment. So again, no landlord right now is going to build in a clause where they just reduce the rent across the board. Many landlords, or if not all landlords, are giving concessions now with the hope and the expectation that they're going to be paid back at some point down the road. So again, if you are trying to work out these different clauses, be very careful with the language, and make sure to have an attorney draft it, because you don't want to be in a situation where you inadvertently gave the tenant a lifetime discount in rent on this apartment.
Yeah, and also, guys, as a reminder, keep in mind the new rent laws that we do have. It used to be that leases, you would typically, in some cases, you'd send them out with only 30 days notice on whether or not you're going to renew the tenant. When the rent laws changed, if we have a tenant, how much notice you have to give on whether or not you're renewing, or not renewing, or even increasing the rent by more than 5%, check the statutes or speak with an attorney before you determine that date. Because for the most part, if a tenant's been in the apartment for more than 2 years, you've got to offer them 90 days notice, or tell them 90 days in advance if you're not going to renew the lease, or if you're going to increase their rent by more than 5%. So be mindful of these days, because sometimes the tenant will come back and say, "Oh, well, you didn't give me 90 days notice like you're supposed to," and you've got to do some resetting of the clock in some cases. So be careful to abide by those dates. Those are more of the minor laws that change that, weren't as popular as, for example, the 1 month security rule. So keep in mind that, it's not just 30 days notice. Even on a month-to-month lease, if we're going to terminate a month-to-month, it might not just be 30 days notice anymore. It could be up to 90 days notice we have to provide to terminate those leases. And it all determines how long the tenant's been in the apartment. If he's been in the apartment for less than 1 year, you can give 30 days notice. Between 1 and 2 years, you can give 60 days notice. But more than 2 years, you've got to give 90 days notice. And that's if you're going to either terminate the lease, like not renew the lease, or increase it by more than 5%.
What else? What other scenarios, issues?
Wait, would you just say that again? If a tenant has been there for less than 1 year?
Correct. If he's in occupancy for less than 1 year, or the lease is less than 1 year also, it would only be 30 days notice.
30 days notice, yeah. And
then
you say 1 to 2 years?
Yeah, and Andrew and David, correct me if I'm wrong, but if he's been in it for more than 1 year but less than 2 years, and also the lease is less than 2 years, like you have an 18-month lease, then it's only 60 days notice. If either the lease is longer than 2 years or the tenant's been there longer than 2 years, you've got to give them a full 90 days notice.
Yeah.
Thank you.
Dylan, I would actually run a situation by you. This is something I've been dealing a lot with. Have you been seeing a lot of tenants that sign leases to take possession of apartments in the city, say, May 1 or even June 1, and now saying they want to back out of the lease after they already signed and they don't want to come to the city at all and take possession of the apartment? Have you been seeing a lot of that?
Yeah, I mean, there's a fair amount of that as well. I mean, there's situations where somebody signed a lease before this happened and all of a sudden life circumstance changed and they don't want to come. And, provided the lease has been approved by the condo and you're not stopping the move in, technically the lease is in effect and you've got to negotiate something with the tenant. Sometimes it's horrific. This is a little cagier because it's not just I changed my mind. I don't want that apartment anymore. A lot of times it comes with kind of bad circumstances. So landlords have to be a little more flexible. Technically you'd be entitled to probably keep the 1 month rent security. But unfortunately in today's, when we're getting those kind of circumstances, it comes along with I lost my job or I got sick or, something that the landlord's got to be a little bit more flexible on than he would normally be.
Yeah, in that case, I have actually yet to see a landlord return any funds they've received to that point. 1 month security deposit. I've yet to see a landlord return it. On the flip side, I'm seeing a lot of tenants sort of accept that as a sunk cost at this point and say, that's the price I'm going to pay for breaching this lease. So I have seen a number of such agreements be worked out between landlord and tenant. I've even had scenarios where the tenant paid, additionally past the 1 month in security deposit in order to get a termination from the landlord for an apartment which they never even took possession of.
Yeah, I mean, that's definitely been an across the board situation. I do also want to touch on turnover work as well, because that's been a popular concept that we're dealing with, especially as landlords, which is in a lot of cases, even if buildings are allowing move in and move outs, they might not necessarily allow us to do turnover work, right? And right now, the official order from the state is you can't do any construction. It's completely banned. That has not been lifted. I heard rumors it might have been lifted upstate, but I'm not sure, but definitely not downstate. It has not been lifted yet. So technically, we can't get contractors and stuff in to do the apartment. This is another case where we're going to have to be creative and come up with an alternative strategy. And in cases, where we have helpful supers, we've been relying on our supers to help us with turnover work. And, I'd reach out if you have a relationship with the building or, the super, see if, a handyman or the super would be willing to help us with that turnover work in the time being. Alternatively, if you just can't get the apartment painted, we've been doing one of two things. If the apartment's really not that bad of shape, we've been negotiating credits with our tenant. Hey, we would love to paint the apartment, make it beautiful before you move in. However, we can't now. Why don't we give you, whatever, it depends on obviously the apartment and the price point, but let me give you $2,000 as a credit and you can do whatever you want with it later once things open up. Or we'll come in after the ban is lifted and maybe paint while you're away for a few days or something like this. I would do that with basic, touch-ups and, minor fixes. I would not make that deal of doing it later for, floor work or something like that, which would require moving furniture out of the apartment or at least to the other side and doing the floor in sections. I'd be careful about what you're agreeing to do later because, things like floors are impossible to do with a tenant in, although it can be done. But again, I would document whatever deals you're making. And in some cases, the tenant saying, you know what, it's not bad. I don't care about it. I'll just take it in current as is condition and that's it. But whatever you do agree, make sure you document it so there's no argument about it later.
All right. Anyone else? Any other questions? I think we covered a lot here. Any party
other questions anybody has?
All right, I think we're good.
This was so helpful. Thank you so much, Dylan and Andrew. I really, really, really appreciate it. Thank you.
No problem. And guys, if you have any questions about individual circumstances or you want to run by a scenario that you're dealing with, please, if it's a legal question and you want to speak to Andrew and David, absolutely. But if it's something operational that a landlord would know, please reach out. I'm happy to walk you through the, any circumstances you guys might have, and at least give you my perspective on how I would approach it if I were dealing with that situation. Julia just had another great question of who is paying for the landlord's loss. To cover that topic, right now the landlord hasn't been offered anything. The only thing that's actually been offered to landlords as any stimulus or relief is the fact that they can defer their mortgage payment for 90 days. However, keep in mind on the 4th month, you have a big balloon payment. I'm not sure how that really helps anyone, because if the landlord wasn't paying the mortgage in the first place, it's probably because he didn't have the money and he wasn't stockpiling cash on the side. So I don't know how he's gonna make that 4-month payment, but that's the only relief he's been given. They can't get PPP loans. Any of this other emergency relief does not apply to landlords. So unfortunately, unless the legislature comes up with something creative, the landlords really don't have much. Hopefully that'll change and they'll give the landlord something, but also when they gave the relief, they said 90-day deferment on mortgages. What about our landlords that don't have mortgages? There's still a ton of other expenses we have to pay. There was no extension of property taxes. We had to pay those in full. Common charges are due every month. We still have to pay the doorman and the super and the elevator expenses. Insurance, we got to pay that. Whatever breaks in the apartment. So, unfortunately, the response to that question, Julie, is right now, nothing. Cuomo claims he's going to offer the landlord something. I don't know what that means. The city, obviously, or state, in light of all the emergency expenses they've had to pay over the past couple of months, obviously isn't very cash rich. So I don't think they'll be able to reduce property taxes or anything, but we'll see how it goes and we'll see if something is offered.
All right. Rock and roll. Stay strong, everybody. Go get them.
Andrew, I
Yes.
have one very, sorry about the wind, a very least specific question.
Can't hear you, Jude. Close your window.
I'm out on the street now, but you know how every lease has a very specific clause about that you have to cover 80% of your floors with rugs or carpeting, that kind of thing? Supposing somebody has a lease and they're on the main floor, they're on the ground floor of a building, so there is nobody below them. And they don't want to cover their floors. Is that 80%? Is that a standard law, or is that something that could be removed from the lease?
David, Dylan. It's not a law, it's a building policy, right? And I guess
mean, it's sort of so standard in like boilerplate leases.
yeah, and it's in a lot of building bylaws and house rules. And I guess they can speak to, listen, I don't know how many, buildings actually enforce it these days. You guys know better than I would, but I guess they can, make a practical, argument to the board or to whoever, the managing agent, saying it shouldn't apply to us, right? From a pragmatic practical approach, it doesn't make sense. Yeah.
Yeah, dude, we throw that into all of our leases automatically, and it's just boilerplate language that we throw in there, and we never enforce it. The only time we'll ever consider enforcing it is if there's a complaint from downstairs. Otherwise, what do we care? The whole point of that rule is to prevent noise intrusion to below. If there's no one to below, then I would definitely reach out to management and say, hey, if they're the ones that are forcing you to put it in, I would say, hey, we're on the ground floor and there's no one below us. Can we get a waiver? And typically they'll agree to allow you to strike it if you're on the floor.
No, this is a sublease from a condo, condo owner. It's a condo.
But who wants it in the lease? The owner or the condo board?
The owner has it in their lease, but it's I'm sure that was pulled from standard.
It was just a boilerplate lease that the broker, the attorney just didn't take out. It's not really applicable.
Okay, so do you think we should just say to the tenant, don't worry about it, just sign and don't worry, because there's nobody below you, so nobody's going to issue a complaint?
I mean, listen, the right way to handle this is to cross it out, get it out of there. Or if it's still in there and there's a lease, this is where we don't want to cut corners. We want to be careful. Listen, you're asking me from a legal perspective or a practical perspective. Legal perspective is, get permission. Practical perspective, who's going to know? It's like, who's going to know? Unless like the building, board member who's likes to cause ruckus, peeks into your home, who's gonna know?
Okay. All right. Thank you so much.
All right. So everybody have a great evening. We're all here for you if you need anything. Stay strong. I think the last week or two, we've seen a little uptick in our purchase sale business. Hopefully, that momentum continues. And I think it's just a matter of just staying consistent and staying relevant and offering information to your clients and your circle, because things will start to build up little by little for sure. All right. We'll talk soon.
Thanks, Andrew and David.
Thanks,
Thanks,
everybody.
everyone.
Guys. Bye-bye.
Many thanks, Andrew. Many thanks, Dylan. Bye, everyone.
Yes. Bye, Anna.